ಸರ್ 9868 ಅಂತ ಒಂದು ಅಪೀಲ್ 2020 ಡಿಸ್ಪೋಸ್ ಆಗೋಗಿದೆ. ಅದ್ರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಾಕಿದ್ದೀನಿ ನಾನು ಎರಡು. ಇಲ್ಲ ರೀಕಾಲ್ ಮಾಡಿ ಜಜ್ಮೆಂಟ್ ಮಾಡೋ ಕನೆಕ್ಟೆಡ್ ಕೇಸಸ್
ಇದು ಕೊಡ್ಲಾ
ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಯಾರು ಮಾಡಿದ್ದಾರೆ? ಯಾರು ಮಾಡಿದ್ದಾರೆ?
ಯಾರು?
ಸಿಂಗಲ್ ಡಿವಿಷನ್ ಹೋಗುತ್ತೆ, ರಿಟೈರ್ ಆಗಿ ಹೋಗಿದ್ದಾರೆ.
ಇಲ್ಲ, ಅದು ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ತಿಳ್ಕೊಂಡು
ಸಾಹೇಬ್ರು ಇದ್ರಲ್ಲ
ಇವ್ರ ಹತ್ರ ಮೂವ್ ಮಾಡಂಗಿಲ್ಲ.
ಸ್ವಾಮಿ
ಇವ್ರು ಮಾಡಿರಲ್ಲ.
ಇವರೆಲ್ಲ ಮಾಡಿ
ಹೌದು, ಇವರು ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು ಇದಾರಲ್ಲ.
ಯಾರ ಮುಂದೆ ನೋಡ್ಕೊಂಡು ಯಾರು ಮೂವ್
ಅಲ್ಲ, ನನ್ನ ಹೆಸರು ಇತ್ತು, ಬಟ್ ಅವ್ರದ್ದು ಒಕ್ಕಲತ್ತ
ಮಾಡಿದ್ರು ಸಹ ಇವರು
ನೋಟ್ರಿ ಇದ್ರೆ ತಿಳ್ಕೊಳ್ಳಿ ಫಸ್ಟ್ ತಿಳ್ಕೊಂಡು.
2020
ಡಿಬಿನ
ಇದ್ರಲ್ಲ ಅವರು ಬೆಳಿಗ್ಗೆ ಮಧ್ಯಾಹ್ನ ಬರಲಿ ಸರ್. ನಿನ್ನೆ ಒಂದು ಮ್ಯಾಟ್ರ್ ಇತ್ತು ಅಂತಲ್ಲ ಸರ್, 58 ನಿನ್ನೆ ಅದು ಇಬ್ಬರ ಹೆಸರು ಇತ್ತು, ತಾವು ವಕಾಲತ್ ಹಾಕಿದ್ರು ಅದರಲ್ಲಿ.
ಆಮೇಲೆ ಏನಾಯ್ತು? 21 ಮೇ
ಸರ್ ಅಡ್ಜರ್ಮೆಂಟ್ಸ್ ಪೇಜ್ ವೈಸ್ ಅಡ್ಮಿಷನ್ ಇಂದ ಅದರ್ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ. ಫ್ರೆಶ್ ಮೆಮೋ, ಸ್ಟೇ, ಎಕ್ಸಿಕ್ಯೂಷನ್, ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಇದ್ರೆ ಮಾತ್ರ ಮೂವ್ ಮಾಡಿ. ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡಿ.
ನೀವಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಹೇಳಿದ್ರೆ
29 ವರ್ಕಿಂಗ್ ಇದೆ. ಆಮೇಲೆ ಚೇಂಬರ್ಗೆ ಹೋಗಿ ಅದನ್ನ ಫೈಲ್ ಅವ್ರಿಗೆ ಕೇಳಿ, ಈಗ ಆಸಿಫ ಹೇಳಿದ್ರು ಅಲ್ಲಿ ಹೋಗಿ ಕೇಳಿ ಬ್ರಾಂಚ್ ಇಂದ ಇದ್ರೆ ತರಿಸ್ಕೊಂಡು. ಈಗ ಫೋನ್ ಮಾಡಿದ್ರು, ನೋಡ್ಕೊಂಡು ಮಾಡಕ್ ಹೇಳಿ. ಡೈರೆಕ್ಷನ್ ಪ್ರಾಬ್ಲಮ್. ಯಾರು ಇಲ್ಲಲ್ಲ, ಯಾರು ಬರಲ್ಲ. ಅವ್ರಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆ ಎಷ್ಟು ಗಂಟೆ ಮುಗಿತು? ಬಂದು ಹಂಗೆ ಹೋಗ. ಇವ್ರು ರೆಡಿ ಇದ್ರೆ ಆಗುತ್ತೆ ಡಿಸ್ಕಸ್. ಇದು ಆಯ್ತಲ್ಲ ನಿನ್ನೆ. ಇದೊಂದು ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಬೇಕಾಗಿತ್ತು. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಸರಿ ಹೋಯ್ತು.
Both the insurance company appeals, rest of execution, it may be taken up on Monday.
Insurance company appeal not for stay, my lord, Monday.
Hello, sir,
Tuesday.
file an IF for stay the execution. proceedings, my lord. Shall you have it on Monday?
New case, my lord, for notice, new case. Fresh case.
With your lordship's kindly,
Yes,
serial number 27, Suguna Reddy has gone to ceremony, her brother-in-law ceremony,
Serial number 77.
27.
Wait, wait, please.
Page wise ಕರಿತೀವಿ. Adjournments page wise from admission, page 5, 21 to 24.
My lord, serial number 21, my lord, 21 and 22.
Yes, Mr. Council.
May kindly be referred to Lok Adalat, my lord. Other side also requested to refer this matter to Lok Adalat.
Sri D. Vijay Kumar, Land Council for respondent number 3 appears through VC and seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
21 and 22, both are same.
Page 6, 25 to 29.
Serial number 27,
27, yes.
she has gone to her brother-in-law ceremony. Today it is not, praise for 1 week,
Your good name, Amma.
Vanaman.
Srimati Vanamala, representing Sri Suguna R. Reddy Land Council on record for the appellants, submits that Srimati Suguna R. Reddy is unable to attend the court on this day due to personal inconvenience, seeks time. Hence, stand over 27th September.
Other side inform ಮಾಡಿ ಮೇಡಮ್. B.A. ರಾಮಕೃಷ್ಣ ಅವರಿಗೆ.
ಮಾಡ್ತೀನಿ.
Page 7, 30 to 34.
But serial number 32, my lord.
32, yes.
I am for the appellant, my lord. Kindly in this matter refer to Lok Adalat, my lord.
At request of Sri
KV 9.
KV Naik, Land Council on record for the appellant, the matter is referred to Lok Adalat for settlement.
My lord, serial number 30, my lord.
Yes,
I have forwarded the appeal memo to the company. My lord, they are forwarding it, my lord, a week's time may be granted.
this is 2021 matter. Mr.
Yes,
Council.
my lord, yes, my lord.
Let us see, next.
Page 8, 35 to 40. Page 9, 41 to 46.
My lord, serial number 41, my lord.
Yes,
This matter is connected with 3898/23. Filed by the claimant against very same judgment.
Vijay Kumar appears online and submits that the present appeal is connected with
Number ಹೇಳಿ sir.
3898/23.
seeks to list both the matters on the same day. Full stop. In the light of the submission thus made, registry to verify and to list the present appeal along with MFA so and so on 25th October.
Much obliged.
Page 9. Page 10, 47 to 50. For order, serial number 1, BP Radha.
Serial number 19, my. Serial number 19. Posted for further hearing. We require some clarification from the company regarding the coverage to NFPP. I request your lordship to kindly accommodate a week.
Started matter next
Started
week, we
matter.
want next week.
Sri Ravi Samprati, Land Council for R2, seeks a week time to proceed with his submission. Full stop. Time as prayed for is granted. List on 19th September.
With my lords kindly, my lord. Serial number 47. 47, my lord.
40?
7.
47.
Yes, Mr. Council.
My lord, I appear for the appellant. Some short accommodation, my lord. I have some inconvenience and health issue.
What is it?
Any short week. Next week, your lordship.
Land Council Sri B.S. Umesh for appellant appears through VC and seeks time, stating that he is suffering from ill health. Full stop. Therefore, list the matter on 26th September. List both the matters on 26th September.
Other side inform ಮಾಡಿ sir, Umesh. Serial number 1, BP Radha.
For the appellant's counsel.
My lord, the notice to respondent number 2 may kindly be dispensed with, my lord, because in the connected matter, though served, the respondent has remained has not appeared with the court, and this honorable court has held in notice as sufficient. So in this appeal also, my lord, notice to R2 may be held sufficient, my lord.
We cannot state so, Mr. Council. Each appeal is different,
No, it seems arising of the same accident, my lord.
but both are different.
No, I'll file a memo, my lord, to dispense. Yes.
We'll call at the end of the list. File with
Please.
Pass over. Serial number 2, Shankar Prasad MB, Renuka HR. Serial number 2, Shankar Prasad.
My lord, by Monday, I'll file the wakalat, my lord.
This is 2022 matter, Amma.
My lord, in fact, my lord, what happened is, I have filed wakalat. Your lordship, my lord, on the last occasion said, my lord, that NWKRTC, since it is not a party, I cannot, because I have filed wakalat on behalf of a corporation which has to satisfy the award. But the party is KSRTC. In fact, my lord, in his own interest, the claimant should implead NWKRTC as party, my lord.
Srimati Renuka HR appears through VC and seeks a week time to file wakalat. Full stop. The appeal is of the year 2022. Full stop. However, to accommodate time as prayed for is granted. List on 4th September.
Obliged.
Serial number 3,
List on. It would be listed on 12th September, Amma. 12th September.
Madam, 12th September. Serial number 3, Geeta R, C. Shankar Reddy.
Let I appear for the appellant's counsel, filing memo for dispensation of notice to respond number 2 and 3.
Why?
My lord, the appeal is only on the question of negligence and quantum, no liability.
Learned counsel Sri Ravi S. Samprati, representing Srimati Geeta R. Learned counsel on record for the appellant, files a memo seeking dispensation of notice upon respondents 2 and 3. Full stop. Learned counsel states that as no relief is claimed against respondents 2 and 3, comma notice to respondents 2 and 3 may be dispensed with. Full
My lord,
stop. Having
regarding-
considered the submission thus made, comma notice to respondents 2 and 3 stands dispensed with, however, at the risk of the appellant. Yes.
Respondent number 1, my lord, I've had application to withdraw the amount.
My lord, their cross objection is also there.
Objection also you have filed.
It may be clubbed along with that. Any date next week, it can be disposed of.
Yes. Sri, your good name, Mr. Counsel?
C. Shankar Reddy.
Sri C. Shankar Reddy, for respondent number 1, submits that respondent number 1 filed a cross appeal wide
40
MFA
40
crop
bar 23.
Huh?
40 bar 23.
40 of 2023, seeks to list both the matters on the same day. Full stop. In the light of the submission thus made, register to verify and to list present appeal along with MFA crop so and so on 19th September.
Obliged.
Yeah, sir, filed application for withdrawal of funds.
Yes, on that day, if the appeal could be disposed of, will.
Serial number 4, BC Shivannegowda.
This case, I agree with it. There was a mistake committed by the tribunal. That the date of accident, actual date of accident is 38/2014. But in the judgment, first para, they have written the date of accident is on 2018, 38/2018. Instead of 14, it is written, but the next para 12 may kindly be seen, my lord, judgment, date of accident. 34 RTA on 38/2014.
Even in the issues, it is mentioned as 38,
Correct, my lord.
2018, Mr. Counsel. Get
The-
it corrected.
Evidence was adduced by Rajendra, the Rajegowda, who is the petitioner before the court. But in the evidence also, certificate copy.
Maybe, Mr. Counsel, but the typographical mistake should be corrected. Learned counsel, Sri B.C. Shivannegowda seeks time to file the corrected copy of the impugned order. Full stop. Hence, stand over to
Four.
25th September.
Serial number 5, B Pradeep.
For the appellant. Council submission regard my lord, Chola Mandalam and Chola MS. Both are one and the same companies, my lord. Shortly, they have mentioned Chola MS, my lord. Another objection is, my lord, date of accident is 22/7/2021. Except, my lord, page number 3 of the judgment. Apart from the page number 3, my lord, other pages, my lord, which date of accident is clearly mentioned. Issues also clearly mentioned, 22/7 only. Only one page, my lord, first page, that has mentioned 21/7.
Heard Sri Pradeep B, Land Council for the appellant. Full stop. Land Council submits that the appellant is Cholamandalam MS General Insurance Company Limited. And in the impugned order, the name of the appellant is mentioned as Cholamandala MS General Insurance Company Limited. Full stop. As the discrepancy is negligible, comma, the office objection in that regard is overruled. Full stop. So far as the next paragraph, so far as the second objection, that is in respect of date of accident is concerned, comma, at para 2 of the impugned order, the date of accident is mentioned as 21/7/2021. However, in the issues, it is mentioned as 22/7/2021. Full stop. The typographical error is required to be corrected. Full stop. Time for 4 weeks is granted to Sri Pradeep B to file the corrected copy of the judgment. List on 26/9.
Hearing on IA, serial number 6.
For the
Yes,
appellant, my
Rajamma.
lord, I will serve the copy, my lord. I have to serve, my lord.
So far, I have not filed wakalat because in spite of court directions, they have not furnished the copy. That is the problem.
I will furnish it, my lord. That recommendation, my lord.
2022 matter, Mr. Council.
Please, my lord. I will serve it, my lord.
Sri Rajarama S seeks time to serve copies of appeal papers to Sri C. Shankar Reddy, Land Council for respondent number 2. Full stop. The appeal is of the year 2022. Full stop. However, to accommodate, a week time is granted. Full stop. In case copies of appeal papers are not served within such time, comma, the appellant would be at liability to pay costs of ₹500 to High Court Advocates Library Fund. Released on 27/9.
Much obliged.
Serial number 7. Gopal Krishna N.
For appellant in this case, my lord. My lord, there's a connected matter in this, my lord. 68/24. Kindly, it may be connected along with.
Land Council Ms. Smita representing Susmita representing Sri Gopal Krishna N. Land Council on record for the appellant submits that MFA
68/24.
68/2024 is connected to the present appeal. Seeks to list both the matters on the same day.
And kindly notice may be issued, my lord.
Registry to verify and to list the present appeal along with MFA so on so.
The liability matter, kindly notice may be issued, my lord, for both the parties.
Issue notice to respondent number 1 on furnishing the requisites. Sri E.I. Sanmati is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri I. Sanmat. Issue notice to respondent number 1 in the appeal as well as in IA 1 of 2024.
Much obliged.
List on 24th October.
Much obliged.
Serial number 8, Prithviraj BN.
For the appellant. There's a delay of 118 days delay. There's a injury case seeking for enhancement.
Issue notice to respondent number 1 in the appeal as well as in IA 1 of 2024 on furnishing the requisites. Sri H.C. Vrishabhendraya is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri H.C. Vrishabhendraya. List on 6/11.
Serial number 9, Narasimha Murthy.
For appellant, my lord. My lord, this claimant appeal and the compensation awarded by MACT was 7,25,318. We are filing for enhancement of the compensation. My lord, there's delay of 95 days. That is because the appellant, that is our client, has suffered for disability. He's 50% disabled.
Let the notice be served.
Yes, thank you.
Issue notice to the respondents 1 and 2 in the appeal as well as in IA 1 of 2024 on furnishing the requisites. Sri Ravish Benny is called upon to accept notice for respondent number 3 and file wakalat subject to entrustment of the case otherwise by respondent number 3. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri Ravish Benny. List on 8th November.
Thank you, my lord.
Serial number 10, B Pradeep.
Serial number 10 and 11 connected matters. In both the cases, my lord, the check issued towards premium, it got bounced, my lord. Policy has been changed.
Let us issue notice.
Please, please, please.
Issue notice to respondents in the appeal as well as in IA 1 of 2024 and IA 2 of 2024 on furnishing the requisites. List on 11th November. Number 10 and 11, both.
Yes. Serial number 12, B Pradeep.
Well, in this case, we are challenging the negligence aspect. 50% negligence has been fixed against the insurer of the auto rickshaw, my lord. The interpleadings and charge sheet, my lord, the driver of the tractor and trailer alone is responsible for the alleged accident.
Heard. Sri Pradeep. What is IA 2?
IA 2 for stay, my lord.
IA 3 for stay, IA
for
1 for delay.
That is,
IA 2
that is dispensation of production of certificate.
disposed of, yes. IA 3 of 2024 is filed seeking the court to stay the operation of the order, operation of the award that is passed by the Motor Accidents Claims Tribunal Bangalore in MVC 2095 of 2019. Full stop. Learned Counsel Sri Pradeep B submits that though the insured, the driver of the insured vehicle was not at fault, the tribunal fastened the liability against the appellant and agreed by the same, the appellant preferred appeal. Full stop. Learned counsel thereby seeks to stay the operation of the impugned award. Full stop. Having considered the submission thus made, comma, this court considers desirable to grant the relief claimed, however conditionally. Full stop. Thus, the operation of the award that is passed by the Motor Accidents Claims Tribunal, Bangalore, in MVC 2095 of 2019, dated 5/1/2024, shall stand state until further orders on the appellant, petitioner appellant depositing 50% of the awarded amount, 50% of the awarded amount which he is liable to pay, along with accrued interest, within a period of 4 weeks before this date. Next, on such payment, our registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Full stop. Issue notice to the respondents in the appeal as well as in IA 1 of 2024 and IA 3 of 2024 on furnishing the requisites. List on 12th November.
Number 13, B. Pradeep.
13, my lord, in this case challenging quantum of compensation, my lord. As per the other card, my lord, the deceased was aged about 57 years, my lord. The 48 years has been considered by the MSCT, and the future prospects considered 25% instead of 10%.
So, pay 50% and we'll allow the.
Please, my lord, I restricted my liability, only 14 lakhs is the excessive amount.
Heard, Sri Pradeep B. Learned counsel for the appellant. IA 2 of 2024 is filed, seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, CERA, in MVC 691 of 2020, dated 15/9/2023. Full stop. Learned counsel Sri Pradeep B. contends that without applying the established principles of law regarding adding of future prospects and multiplier, and applying the appropriate multiplier, comma, the tribunal awarded excess sum as compensation and therefore agreed by the sum awarded, an appeal is filed. Full stop. Learned counsel thereby seeks to stay the operation of the award. Full stop. Next, having considered the submission thus made, comma, this court is of the view that stay as prayed for is required to be granted, however conditionally. Full stop. Thus, the operation of the award that is passed by the Motor Accidents Claims Tribunal, Additional Motor Accidents Claims Tribunal, CERA, in MVC 691 of 2020, shall stand state next. Proof of deposit to be filed. Next, on such deposit, comma, the respondents 1 to 3.
No, my lord, one is dead, my lord. During the pendency of the petition, wife is dead. I made a note that, my lord. 2 and then 3. I think, my lord, 1 and 2 ne ಆಗ್ತಾರೆ.
There
Padma,
are 3.
3, my lord, but since dead, since dead, during the pendency of the petition itself, wife dead.
Yes, 3 are there. After the wife is no more, 3 are there.
No, my lord, that's owner of the vehicle.
Okay. On such deposit, comma, the respondents 1 and 2, oblique the claimants, are permitted to withdraw their respective shares subject to the terms of the award. Full stop. Issue notice to the respondents in the appeal as well as in IA 1 of 2024 and IA 2 of 2024 on furnishing the requisites. List on 13th November.
Serial number 14, Gopal Singh.
For the appellant, my lord. My lord, the incident took place on 26th of December 2021.
Let us issue notice to the respondents, Mr. Counsel.
My lord, I have a submission to make. Today, the execution petition is listed, my lord. Already delivery warrant was issued on the last date. Today, they are gonna reissue, my lord. And this MFA will be in structures if they are successful in executing the the delivery warrant, my lord. So hence, pray for considering the IA, my lord.
You have filed the appeal with delay of 574 days.
Yes, ma'am.
We cannot now stay the operation. You are Mr. Gopal Singh,
I am J. Kishan Sharma. I am also in the Wakalat, my lord.
Sri
Your
J.
name?
Kishan Sharma.
J.
Kishan Sharma.
J. Kishan Sharma, Land Counsel, who represents Sri Gopal Singh, Land Counsel, on record for the appellant. Full stop. Issue notice to the respondent in the appeal as well as in IA 1 of 2024 and 2 of 2024 on furnishing the requisites. List on
My lord, there is a connected matter where the respondent has sought enhancement. That is MFA 664 of 2020.
the Land Counsel states that MFA
664 of 23.
664 of 2023 is connected to the present appeal. Seeks to list both the matters on the same day. Full stop. Thus, register to verify and to list the present appeal along with MFA so-and-so on 5th November.
Much obliged, my lord.
Fresh matter, serial number 15, Gopal Krishnayan.
Owner's appeal. Pending notice making. No insurance.
Issue notice to respondents. Heard Sri Gopal Krishnayan, Land Counsel for the appellants. Issue notice to respondents on furnishing the requisites. Issue notice to respondents on furnishing the requisites. List on 19th November.
Serial number 16, B Pradeep.
For the appellant, this case challenging negligence and quantum, my lord. I restricted my liability. 50% I am ready to deposit and they may permit it to it.
On what grounds you have
My
preferred?
lord, negligence aspect and my lord, there is a done collision between the two motorcycles, my lord. The entire liability has been fastened against the insurer of the motorcycle. And my lord, 30% future prospect has been considered instead of 25%. The interest granted 9%, my lord, instead of 6%.
Heard Sri Pradeep B. Land Counsel for the appellant. IA 1 of 2024 is filed seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal Mangaluru in MVC 1686 of 2022 dated 29/6/2024. Next, Land Counsel Sri Pradeep B submits that though there was head-on collision between two vehicles and the driver of the other vehicle was also at fault, the tribunal fastened the entire liability upon the appellant, which is unjustifiable. Full stop. Land Counsel thereby seeks to stay the operation of the impugned award. Next, having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditionally. Full stop. Thus, the operation of the award that is passed by the Motor Accidents Claims Tribunal Mangaluru in MVC 1686 of 2022 dated 29/6/2024 shall stand stayed until further orders on the petitioner appellant depositing 50% of the award amount along with accrued interest before this court within a period of 4 weeks.
Before MSCT.
Next,
Before.
on such deposit, the appellant on such deposit, the registry is directed to invest the same in any interest-yielding fixed deposit scheme of any nationalized bank until further orders. Issue notice to the respondents in the appeal as well as in IA 1 of 2024 on furnishing the requisites. List on 19th November.
Serial number 17, D Vijay Kumar.
My lord, I am for the appellant, my lord. The appeal by the insurance company, my lord, challenging the negligence, liability and quantum of compensation. My lord, accident between the container lorry and the tempo traveler. My lord, the container lorry was moving in a service road. The tempo traveler came from opposite direction and dashed against the container lorry. Thereby, the accident has taken place. My lord, we have disputed the negligence and liability. I am ready to deposit 50% of the award amount.
Heard Sri D. Vijay Kumar, Land Council for the appellant. IA 1 of 2024 is filed seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Bangalore in MVC 5298 of 2021 dated 12/7/2024. Land Council Sri D. Vijay Kumar submits that though the vehicle of the insured, though the driver of the vehicle of the insured was not at fault, the tribunal fastened entire liability upon the appellant and therefore the appellant preferred appeal. Land Council thereby seeks to stay the operation of the award. Next, having considered the submission, same order.
High Court, my lord, deposit before High Court.
Yes, High Court.
Much obliged.
Serial number 18, Ashok N. Patil.
It's for the appellant in this case, not insurer appeal on the ground of Manot's liability. But there's a delay of 2 days in lodging the complaint. And Manot, the owner come driver, Manot admits in his cross-examination that the vehicle is not involved. But somehow the charge sheet Manot is laid against the said vehicle. But there's a collusion between the Manot's claimants and that's how Manot the liability is questioned.
Heard Sri Ashok N. Patil, Land Council for the appellant. IA 1 of 2024 is filed seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Mysore in MVC 1656 of 2022 dated 3/6/2024. Next, Land Council Sri Ashok N. Patil submits that though the vehicle of the insured was not involved in the accident, in collusion with the claimant, a false case is foisted involving the said vehicle and laid a false claim. Land Council thereby seeks to stay the operation of the impugned award. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditionally. Thus, the operation of the award that is passed by the Motor Accidents Claims Tribunal, Mysore in MVC 1656 of 2022 dated 3/6/2024 shall stand stayed until further orders on the petitioner appellate depositing 50% of the award amount along with accrued interest before this court within a period of 4 weeks. Next on such deposit, same date 14th November.
Please.
14th November. Serial number 19, adjourn. 20, for dismissal, P. Shivakumar.
For appellant filing the dispensation for R2, only direct
You are Mr. Shivakumar.
on behalf of P. Shivkumar,
What is your good name?
Supreet BP.
Heard Sri Supreet, Land Council who represents Sri P. Shivakumar, Land Council on record for the appellant. Land Council files a memo seeking dispensation of notice upon respondent number 2. Land Council states that the entire liability is fixed upon respondent number 1 and therefore notice to respondent number 2 may be dispensed with. Having considered the submission thus made, notice to respondent number 2 stands dispensed with, however at the risk of the appellant. Next. Srimati Geeta Raj is called upon to accept notice for respondent number 1 and file wakalat subject to entrustment of the case otherwise by respondent number 1. Wakalat to be filed within 2 weeks. Appellants to serve copies of appeal papers at the chambers of Srimati Geeta Raj. list on 20th September 20.
Serial number 21, 22 adjourn. 23 KV Nayak, Janardhan Reddy for R2.
Claimants appeal for enhancement. Case of injury. Only
There is the other side.
only two ground, my lord. Income and loss of earning laid up period.
Without other side, how can we dispose? We'll list on next week.
Please.
List. Sri Janardhan Reddy. Directed not to show the name of Sri H.C. Rishabhendraya in the cast list. Full stop. At request of Sri K.V. Nayak, Land Counsel for the appellant, list on 12th September.
Please.
Serial number 24, Sudhakar Reddy, Chandrasekhar Reddy for R1.
My lord, I represent Mr. Sudhakar Reddy, my lord.
Yes.
My lord, this matter may be referred to Lok Adalat, my lord. He instructed me to make submission.
Sri D. Vijay Kumar, representing Sri Sudhakar Reddy SV, Land Counsel on record for the appellant, seeks to refer the matter to Lok Adalat. Full stop.
Much
Hence,
obliged.
the matter is referred to Lok Adalat for settlement.
Much obliged.
Serial number 25. Nataraj Ballad,
I
Shankar
appeal
Reddy.
for claimant. First as one. But records may be needed, my lord, for disposal. P6, P7 is the documents produced by the.
Heard Sri Nataraj Balla A,
Please.
Land Counsel for appellant, as well as Sri Shankar Reddy C, Land Counsel for respondent number 1. Admit, call for the records from the consent tribunal. List the matter under the caption final hearing on 22nd October.
Serial number 26, D. Vijay Kumar, Jagadish HT for.
My lord, I am for the appellant, my lord. If other side is ready, I am ready.
You have not filed wakalat, Mr. Vijay Kumar.
My lord, since I have filed appeal on behalf of BMTC, my lord, the same is arising out of same accident.
True. Even then you have to file the wakalat. You
Please,
can
my lord.
dispose of the matter, but there is no representation for the other side.
Ah.
Yes, 26. Are you ready?
Ready, ma'am.
Yes. Yes.
My lord, this appeal is by the BMTC, my lord, challenging negligence and quantum of compensation awarded by the tribunal.
Yes.
My lord, the accident between the BMTC bus and the motorcycle. My lord, the alleged accident has taken place on 29/7/2018 at about 9:22 a.m. in the morning. When the bus was going from Kempegowda bus stand to Hesarghatta, when in the near the Kurudugere place, my lord, when the bus is taking slowly left turn, at that time, my lord, the rider of the motorcycle came from opposite direction with great speed and in a rash and negligent manner, without wearing helmet and without license also. My lord, he lost balance and came and dashed against the front left bumper of the bus, where the bus was moving on the extreme left side of the road. Thereby, my lord, he sustained, met with an accident and sustained injury because of his own negligence. My lord, there cannot be any negligence on the part of the driver of the BMTC bus. My lord, the complaint was given by his wife, my lord. His wife was not at the place of accident and she went directly to the hospital. My lord, she was there at 3 o'clock. My lord, by that time, the police went to the police hospital. My lord, by 3:30, my lord, she gave a complaint. And the place of accident and the hospital, Aster Hospital, is more than 4 to 5 kilometers. My lord, within 1 hour, my lord, even without the presence of the complainant or any other eyewitness, my lord, police came to the spot, whether they have come to the spot or they themselves prepared the marker and sketch on their own by imagination. And my lord, filed an entire charge sheet against the driver of the KSRTC bus. Though the driver of the BMTC bus has given the complaint, my lord, they refused to take the complaint. And in turn, my lord, they have filed a false criminal case and charge sheet only against the driver of the BMTC bus without proper investigation. My lord, you ask me kindly say, is it possible in a Bangalore city? If the police, they themselves went to the police station, taken the complaint from the wife of the claimant, and my lord, she was not seen the accident and she has not gone to the place of accident, and I don't know who identified the exact place of accident. My lord, the police, my lord, had sued the convenience so as to fix the negligence only on the part of the driver of the BMTC bus. They filed a false criminal case by drawing a false Mahajar and sketch. My lord, kindly see IME report, my lord, exhibit P3.
Yes.
My lord, the IME report clearly says front left portion of the bumper is damaged. My lord, if really the
Yes.
bus met with an accident by head-on collision, there should be an impact between the front right portion of the bus and the motorcycle. Here, my lord, the motorcycle went on the extreme left side of the road and dashed against the left bumper of the bus. That itself very clear that, my lord, it's a reciprocal equator. It makes it very clear that the claimant himself is totally negligent and responsible for the accident.
Yes.
We have examined the driver, and he has clearly stated the way in which the accident has taken place, and the police have filed a false criminal case. In spite of trying to give a complaint to the police, they refused to take the complaint.
Yes.
My lord, here, my lord, accept the evidence of the claimant, my lord. In spite of specific denial of the total negligence on the part of the driver of the BMTC bus, my lord, the tribunal, my lord, without properly considering these aspects,
Yes.
my lord, simply held that the driver of the bus is totally negligent and responsible for the accident. And my lord, tribunal has awarded, my lord, a huge compensation of rupees, my lord, 26 lakh 30,000. My lord, there, my lord, I have taken the contention that, my lord, it is due to contributory negligence, my lord. Instead of 26 lakh 30,000, it is a just and reasonable compensation of rupees 13 lakh 15,150 to be awarded. I have disputed only 13 lakh 15,150. I have restricted my claim. Therefore, my lord, the award of the tribunal should be modified, and 50%, more than 50% negligence to be fixed on the rider of the motorcycle purely based on the IME report. And we have examined the driver. He has also clearly stated that.
You have not examined the driver.
We have examined the driver, my lord, R1, my lord.
R1 is conductor, not driver.
Yeah.
Driver not X.
Yes, Mr. Counsel.
As per the malad, page number 8, malad, judgment, para 11.
Yes.
From the, I permitted to read the, from exhibit P1 to P8, malad, clearly stated immediately after the said accident was registered against the driver of the BMTC bus, malad, and registered bearing number K57F2954. After the detailed investigation, IO has filed a charge sheet against the driver of the bus, malad. And no doubt the accused counsel for the respondent the cross-examination PW1, but in any opinion, nothing has been elicited in the order to disbelieve the both oral and documentary evidence. The respondent, though, appeared filed a written statement denying the negligence on the part of the driver affecting vehicle, but failed to adduce any expert support of their defense. Non-examination of the driver of the BMTC bus bearing number so would be leads to draw an adverse inference. Blood, as per the charge sheet, malad, police investigation against the BMTC bus driver, malad. They are not challenging the charge sheet or the charge sheet, malad. So in the entire negligence on the part of the BMTC bus, malad, and the quantum my appeal also there, malad. The case of injury, malad, 2018 accident, 2018 accident. The injuries is, malad, para 20 may kind is page number 40. The Dr. Sridhar BG, the assistant professor in the neurosurgery Boring Hospital.
The injuries sustained by...
Malade, as for the injuries is malada. Sustained fracture of left PTP, traumatic actual subdural hematoma, tibia and fibula, and fracture of left leg. The doctor assessed PW2 malad assessed disability of 50% of the neurological disability malad, 67%. And malad PW3 Dr. Nagaraju has assessed disability of tibia and fibula malad 37% of the particular limb and 12% of the whole body. Malad, he was in a 46 days, he was in inpatient malad. as per the medical record, shows that my tribunal has taken 50% of the neurological disability and 10% to the tibia and fibula disability. He was a building contractor. He was in 2018 accident and not produced any document to show that he was a building contractor and any other. As per the 2018 accident, notional income has taken 12,500. And pain and suffering is awarded at only 30,000. Food and nourishment 20,000. And medical expenses as per the medical bills are produced before the trial court, 15,48,228. Loss of during later period only 20,000 is awarded. And loss of future income 9,72,000. And to amenities also awarded 30,000. And future medical expenses 10,000 is awarded.
Last may kindly see exhibit P3, my lord, the IME report, my lord.
So the total disability is 60%,
60% neurological disability, Malad. Kindly see, Malad, para 21. PW2 neurosurgery professor, mental disability assessed by the basis of neurosurgery also, moreover, based on assessed disability, examine the petitioner also CT scan, clinical examination, the competent process to assess the disability. Therefore, as a perusal of exhibit P17 and 18 of the evidence of PW 1 and 2, in view of the 62% of the disability on our head is an higher side, but tribunal has taken 50% of the whole body. Total 60% has taken by the trial court. But wife is the...
My lord, in the cross-examination of PW2, my lord, he has clearly admitted in the cross-examination, my lord, he has not given the treatment and the treated doctor are still available in the Astra hospital. He do not know why he has come to him for assessment of disability. I have not found any neurocognitive behavior deficiency to the patient except CT scan and the examination. But absolutely, my lord, he has not found any neurological cognitive behavior. Then that being the case, where is the question of 60% disability, my lord? Even the tribunal also not observed the present condition of the claimant. Doctors have given false evidence. He has not treated claimant.
Since today he was in unsound mind, Malad, represented by wife.
Evidence of PW2 cannot be believed and relied upon. My lord, as per exhibit P32, my lord, he has got a medical reimbursement
That was
No
discussed
document.
by the,
Please.
from United India Insurance Company Limited. Still, the tribunal has awarded huge compensation towards medical expenses.
Given blood there.
Exhibit P32.
Is admitted, my lord, during the course of cross-examination, he has stated that he has not reimbursed the medical bills from the United India Insurance Company. I produced
Allah,
the
their
document.
own document you shows. Exhibit
It was on-
P32.
Mr. Council, there was a discussion at para 18 of the
Of the
order.
judgment.
My lord, without considering exhibit P32, my lord, tribunal has observed it. Accident has taken place in the middle of the road. The evidence, my lord, of course, my lord, in the classification is in Kannada. But she has clearly admitted, my lord, that she has not seen the accident and the accident has taken place in the middle of the road. And my lord, he came and dashed against the left portion of the bus.
Heard.
And all medical documents are duplicate documents.
3D Vijay Kumar, Land Council for the appellant in MFA 3793 of 2021, who is appearing for the respondent in MFA 2401 of 2022. Full stop. Also heard Sri Jagadish HT, Land Council, who is appearing for the respondent in MFA 3793 of 2021, who is appearing for the claimant in MFA 2404 of 2022. Next, both the appeals, that is MFA 3793 of 2021 and MFA 2401 of 2022, arise out of the order that is rendered by the Motor Accidents Claims Tribunal, Bangalore, in MVC 4559 of 2018, dated 8/3/2021. Let's stop. The parties to both the appeals will hereinafter be referred as the corporation and claimant for convenience of discussion. Next, while the corporation filed an appeal disputing its liability to pay compensation and raising a contention that the amount awarded as compensation is excessive, the claimant is before this court dissatisfied with the amount that is awarded as compensation through the impugned order and seeking enhancement. Next. The case of the claimant as projected you remove it. The crux of the case as projected by the claimant is that on 29/7/2018, while he was riding his motorcycle bearing registration number KA04JD 0489 on the left side of the road, cautiously, wearing helmet and following all traffic rules and regulations. And when he reached near Bone Mill Junction, Hesaragatta Main Road, Bangalore, the bus of the corporation bearing registration number KA 57F 2954, driven by its driver at a high speed and in a rash and negligent manner, dashed against his motorcycle, due to which he fell down and sustained grievous injuries. Next. Arguing the matter on the aspect of negligence, Learned Counsel Sri D. Vijay Kumar for the corporation contends that the driver of the corporation was driving slowly and cautiously and tried to turn the bus to his right to enter Hesaragutta Main Road. Full stop. At that time, the claimant came on his two-wheeler in a rash and negligent manner and at a high speed and dashed against the bus, due to which the accident occurred. Full stop. Thus, the claimant is responsible for the occurrence of the accident, but not the driver of the corporation. Full stop. However, without there being any material to fix liability on part of the driver of the corporation, police registered a false case against him. Full stop. Learned Counsel further states that the tribunal, without examining the manner in which the accident occurred, assigned liability against the corporation, which is unjustifiable. Full stop. Next. Vehemently opposing the submission thus made, Sri Jagadish HT for claimant contends that there was no negligence whatsoever on part of the claimant. Full stop. The accident occurred only due to the rash and negligent driving of the driver of the corporation. Full stop. Immediately after the accident, complaint was given to police, basing on which a case was registered. Full stop. After due investigation, charge sheet was also laid against the driver of the bus. Full stop. The said driver of the corporation, till now, has not challenged the contents of the charge sheet to the sufficient material was produced before the tribunal to establish that the accident occurred due to the negligence of the driver of the corporation. Full stop. Considering the said evidence, the tribunal held that the accident occurred due to the negligence of the driver of the corporation. Full stop. Thus, the plea taken by the appellant should not be entertained. Full stop. Next paragraph. It is not in dispute that immediately after the accident, a case was registered against the driver of the corporation. Full stop. Equally, it is not in dispute that the officer who investigated the case, laid charge sheet against the driver of the corporation. Full stop. The corporation did not choose to produce the evidence of the said driver. Full stop. On the other hand, it produced the evidence of the conductor of the bus and got examined him as RW1. Full stop. However, the claimant by both oral and documentary evidence has established that due to the negligence of the driver of the bus, the accident occurred. Full stop. Also, though learned counsel for the corporation, Sri D. Vijay Kumar contends that the principle of res ipsa loquitur is required to be applied, this court does not find any grounds for applying the said principle, as the police records stand against the driver of the corporation, and as the claimant has established through all the evidence that the accident occurred due to the rash and negligent driving of the driver of the bus. Thus, driver of the bus. Next, coming to quantum of amount that is awarded as compensation, when Sri D. Vijay Kumar for corporation contends that the amount awarded as compensation is excessive, the submission that is made by Sri Jagadish H.T. and counsel for the claimant is that the claimant suffers with 100% neurological and physical disability, and thus the compensation granted is required to be enhanced. Full stop. The tribunal through the impugned order, the tribunal through the impugned order awarded a sum of rupees 26,30,228 as compensation, divided under following heads: A to A. Full stop. It is not in dispute that due to the accident, the claimant sustained fracture of left FTP, traumatic acute subdural hematoma, fracture of left tibia and fibula, and right FTP subdural hygroma. Full stop. The said injuries are grievous in nature as per the material that is produced by way of medical record. Full stop. It is also not in dispute that the claimant took treatment as inpatient for a long period of 46 days. Next point. As per the version of the appellant, as a building contractor, he was earning rupees 20,000 per month by the date of accident. Full stop. However, as rightly contended by Sri D. Vijay Kumar and counsel for the corporation, no evidence is produced to establish either the occupation or earnings by the claimant as on the date of accident. Full stop. Perceiving the said fact, the tribunal took the notional income as rupees
9,000.
9,000 per month. Full stop. Arguing on this aspect, Sri Jagadish H.T. contends that the accident occurred in the year 2018, and for the relevant period, even the Karnataka State Legal Services Authority is taking the notional income as rupees 12,500 per month, and at least the said figure should have been considered by the tribunal. Full stop. This court does not find any reason to discard the said submission. Full stop. Also, this court is of the view that the request to take the notional income as rupees 12,500 per month is justifiable in view of the fact that the accident occurred and the claimant became disabled at the age of 39 years, which age is considered to be the right age of having good earnings, of having good earning power. Full stop. Therefore, this court considers desirable to take the notional income as rupees 12,500 per month. Next.
My lord, as per the discharge summary, at the time of discharge, there is no disability as stated by the doctor. It is very clear, my lord.
Two. Dr. Srihari BG assessed the neurosurgical function of the claimant and with the help of CT brain deposit that the disability is 62%. The neurological disability is 62%. Let's stop.
There's no proper calculation at all.
That is PW4, Dr. Nagaraj BN gave evidence to the effect that the physical disability in respect of left lower limb is 37% and to the whole body is 12%. Full stop. Considering the totality of evidence, the tribunal took the neurological disability in respect of whole body as 50% and the physical disability in respect of whole body as 10%. Full stop. The submission that is made by Sri Jagadish HT, Land Counsel for the appellant, in this regard is that the Land Counsel for the claimant, in this regard is that the claimant is still suffering from unsoundness of mind due to head injury, and thus even the claim petition is filed by his wife representing him, and the present appeal and the appeal is also filed
In this regard, my lord, PW doctor has not stated anything about all those things. That is the drama created by the claimants.
Full stop. In the appeal filed by the corporation, that is in MFA 3793 of 2021, the corporation in the cost title itself mentioned as follows.
My lord, one submission. If you write any different thing, my lord, court will not accept. Even the office objection will be raised. We cannot put a different thing.
Mr. Counsel, when we are dictating the
Yes, my lord, because your lordship has observed like that.
Follows. Full stop. In this regard, Land Counsel Sri D. Vijay Kumar submits that the cost title as mentioned in the pleadings of the claimant are mentioned in the appeal, full stop. Keeping aside the said aspect, comma, the evidence, this court does not find any reason to discard the evidence of PWs 2 and 4, who with all their expertise in their respective fields have gave clear findings with regard to the functional disability, neurological and functional disability of the claimant. Full stop. Though the evidence is of PW2 is that the disability is 62% neurologically, and the evidence of PW4 is that the disability, the physical disability in respect of whole body is 12%, the tribunal took the neurological disability as 50% and the physical disability as 10%. Full stop. The said observations and assessment by the tribunal therefore needs no interference. Full stop. Next. It is not in dispute that the claimant was aged about 39 years by the date of accident. Full stop. Thus, the appropriate multiplier to be applied as per the decision of the Honorable Apex Court in Sarla Verma's case is 15. Full stop. Also, 40% of the earnings are required to be added towards future prospects as per the decision of the Honorable Apex Court in Pranay Sethi's case. Full stop. The disability of neurological and physical together is 60%. Full stop. Thus, the compensation which the claimant is entitled to under the head loss of future earnings due to neurological and physical disability is as under. Notional monthly income 12,500, annual income 1,50,000, add 40% towards future prospects 2,10,000, apply appropriate multiplier 15, 31,50,000. Disability, permanent disability being 60%, loss of future earnings 18,90,000. Stop. Having considered the nature of injuries sustained, that is multiple fractures, this court is of the view that the claimant is entitled to rupees 60,000 under the head pain and suffering. Full stop. Also, taking into consideration the fact that the claimant took treatment as inpatient for 46 days and sustained 46 days but multiple fractures and injuries sustained by him, this court is of the view that the claimant would not have attended his normal pursuits at least for a period of 6 months. Full stop. Thus, the loss of earnings during laid up period comes to rupees 87,000 within brackets 14,500 into 6. Full stop.
12,500.
Thus, the compensation which the claimant is entitled to under different heads is as under. Compensation for pain and suffering 60,000 towards food, extra nourishment, conveyance and attendant charges 20,000, medical expenses 15,48,228, loss of income during laid up period 87,000, loss of future earnings 18,90,000, loss of amenities in life 30,000, future medical expenses 10,000. Add all that. The tribunal through the impugned order has awarded a sum of rupees 26,30,300 as compensation. Full stop. However, in the light of the foregoing discussion, this court is of the view that the justifiable sum which the claimant is entitled to as compensation is so and so. Full stop. Thus, both the appeals are disposed of with the following order.
Interest at 6%, my lord, and I think there is some delay in filing the appeal by the claimant.
Before that, you write another thing. Full stop.
We have challenged the interest also.
Yes, Land Counsel for the corporation, Sri Vijay Kumar, raised an objection with regard to the interest that was awarded by the tribunal. It awarded 7%, Mr. Counsel.
7%.
Yes, my lord, make it 6%, my lord, on the entire compensation.
With regard to the interest that was awarded by the tribunal. Full stop. Land Counsel states that the tribunal awarded interest at the rate of 7% per annum. However, the justifiable interest is 6%. Full stop. Sri Jagdish HT did not raise any objection to order payment of compensation with interest at the rate of 6% per annum. Full stop. Thus, the appeal is disposed of with the following order. Both the appeals are allowed to pass. The compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, through orders in MVC 4559 of 2018, is enhanced from 26,30,300 to so and so. Next. The interest that is awarded by the tribunal is reduced from 7% to 6%. Full stop. Next, the total compensation carries interest at the rate of 6% per annum from the date of petition till the date of deposit. Next, the corporation is directed to deposit the entire sum within a period of 8 weeks from the date of receipt of copy of this order. Full stop.
Amount in deposit to the
1 minute.
Amount in deposit may be transferred to the tribunal.
Out of the enhanced sum, comma, the claimant is permitted to withdraw 50%.
Please.
Full stop. The remaining sum shall be invested by the tribunal in any interest yielding fixed deposit scheme for a period of 5 years. Full stop. On completion of the said period, comma, the claimant is permitted to withdraw the entire amount along with accrued interest. Next, the amount, if any, in deposit before this court be transferred to the concerned tribunal immediately.
Lord, kindly see, is there any delay in filing the appeal by the claimant?
Num appeal. 240. Num appeal. Ide delay ide.
Both the appeals are in time, Mr. Counsel.
Please, man, because my lord, appeal was disposed of before the tribunal on 8th March 2021. They have filed appeal in 22. 22 they have filed appeal.
COVID period it was not. COVID benefit.
In time, Mr. Counsel.
Please, my lord, I'm sorry, my lord.
Because of the COVID.
Please, my lord.
Please.
Please, my lord. Much obliged.
Please.
Serial number 28, 27 adjourned, 28, Girish B. Baldare, B.S. Krishna for R2.
I didn't.
28 Proxy Council, my lord, kindly up next. 28, my lord, for the appellant. Proxy Council, my lord, kindly up to next week any date.
Sri Jagadish HT, representing Sri Girish P. Baldari, Land Council on record for the appellant, seeks time. No representation on respondent side on call. Stand over to 10th September.
Please.
Serial number 29. Latur Suresh. K. Suresh for R2.
For the respondent number 2, I am for appellant in this matter. Kindly grant 1 week time, my lord, in this matter. Issue notice to R1, madam, for R1, second time, madam. I will pay PF in counter, madam.
Ma, last time you submitted that MFA 6437 of 2020 is connected to the appeal. But the office endorsement is that no such record is there.
6496 but 21, 6437 but 21 is connected, my lord.
6437 of
21, my lord.
21.
Yes, my lord.
Full stop. Ma, Srimati, Miss Smita, representing Sri Latur Suresh Mahalingappa submits that MFA 6437 of 2021 is connected to the present appeal. Seeks to list both the appeals on the same day. 21 is already connected, Amma.
Yes, madam.
Manoli. Miss Smita, Miss Smita, representing Sri Latur Suresh Mahalingappa, seeks time. The appeals are of the year 2021. However, to accommodate, what is this in the connected matter notice to
R1, my lord, sir, for second.
R1?
29.1, 64 MS6.
Why you have not furnished the requisites?
My lord?
Why you have not furnished the requisites for sending notice to respondent number 1?
Yeah, filed the first time, my lord. This is for second time, it's okay.
What?
So I will file a PF, my lord.
Land Council seeks time. Full stop. Next month, in MFA 6437 of 2021, the appellant is under liability to furnish the requisites for sending notice to respondent number 1. Full stop. Therefore, the appellant is directed to furnish the requisites within a week. Full stop. On furnishing the requisites, office to send notice to respondent number 1. List on 2910.
Much obliged.
Serial number 30. Rangegowda.
My lord, in this matter, my lord, just now I contacted the insurance company. They are sending the wakalat, my lord. Next week I am going to file. They are forwarding it.
Mr. Counsel, you accepted notice on 5/1/2023.
My lord, the real truth is totally
Since
different, my lord. We
yes.
cannot say before the court.
Sri D. Vijay
Because
Kumar.
many times, my lord, we don't receive the copy of the appeal memo. They furnish it later. All those things are there, my lord. It is some difficulty between us.
Full stop. Sufficient time already granted.
Allah, 1 week time finally.
Accommodate, a week time is granted. No further time will be granted. List on
Please,
12th
ma'am.
September. 12th September. Yes.
Please, my lord.
Serial number 31. K. Vishwanatha. BC Shivannegowda for respondent.
Respondent number 2.
No representation on appellant side on call. To give fair opportunity, list on 17th September.
Serial number 32. Adjourn. 33. P. Shivkumar. B. Pradeep for R1.
Last week they have served the copies, my lord. I will file within 2-3 days, my lord, I will file wakalat.
Sri B. Pradeep seeks a week time to file wakalat for R1. Time as prayed for is granted. Stand over to 17th September.
Oblige.
Sale number 34, Spurti Hegde, Harini Shivananda. Spurti Hegde. Sale number 34.
No representation on either side on call. To give fair opportunity, list on 17th September.
Sale number 35. Sayyid Akbar Pasha.
Maybe refer to Lok Adalat, my lord. It's only quantum issue, that's it.
At request of Sri B. Pradeep, Land Council for R2, the matter is referred to Lok Adalat for settlement.
Oblige.
Sale number 36, Mushtaq Ahmad. A.N. Krishna Swami.
Case of injury.
Where is the other council, Mr. Khan?
In Krishna Swami.
A.N. Krishna Swami.
Only the loss of 4 fingers, amputation of 4 fingers. My lord.
Yes. Heard Sri Mustaq Ahmad.
Yes.
Land Council for the appellant. No representation on respondent side on call. Admit, list the matter under the caption final hearing on 12th September.
My lord, date?
12th September.
Serial number 37, Bhushani Kumar, Ravi S. Samprati.
Here for second respondent.
Case of death.
Quantum is in question.
Yes.
But the deceased was aged 41. He was working as a carpenter. It is stated as carpenter, but he was working under interior designer carpenter. The claimant claimed that he was drawing a salary of rupees 25,000. The tribunal takes it as 14,000. Well, it's para 15 of the judgment. We have produced a letter of the employer saying that he was getting a salary of 25,000 rupees. That has not been seriously disputed by the insurance company. The owner did not appear. He was placed ex parte. In one sentence, the tribunal says, petitioners have furnished the letter issued by the Creative Interior stating that Kumar was interior decorator and skilled carpenter in their firm. But to prove the same, no individual witness is examined.
Yes.
It is exhibit at para 24.
Yes.
The salary is stated as 25,000. That letter is produced as exhibit P9.
Hmm.
On the ground that he was the person who has issued the letter has not been examined, that has been brushed aside. And they have taken it as for only 14,000 as per the legal services
Yes.
authorities.
Yes. We do not find any infirmity in the order, Mr. Council.
But he was not an ordinary carpenter. He was not just a carpenter.
The letter remains unproved. The author of the letter should have been examined to establish that he was working under him and so much wages or the salary was paid. And he was subjected to cross-examination. No effort has been done. The tribunal has considered rightly 14,000 rupees.
In the cross-examination, it is not disputed. The letter is not
Even that the
disputed.
liability is upon you to establish the genuineness of the document.
Even then, my respectful submission is, he was not just a carpenter like any other carpenter. He was working as an
Establish, Mr.
interior
Counsel.
designer. Therefore, 14,
Maybe
taking
he's not just a
14,000 is
carpenter.
on the lower side. I pray for
We do not find
taking
any
it as
grounds.
at least 20,000 rupees it can be.
Heard.
Or it may kindly be referred to Lokadam. I'll take a chance.
Mr. Council, after arguing the matter and after
I'm sorry, I'm sorry.
exhibit our mind, your
At least
good name.
some enhancement, your lordship.
Your good name. We don't find any grounds. Your good name.
Please, madam.
Your good name, Mr. Council.
ತಮ್ಮ ಹೆಸರು ಹೇಳಿ ಸರ್.
C.V. Kumar.
Heard Sri C.V. Kumar, who represents Mrs. Bhushani Kumar, Land Council on record for the claimants, as well as Sri Ravi S. Samprati, Land Council for respondent number 2 insurance company. Next. Seeking enhancement of compensation, this appeal is filed disputing the order that is rendered by the Motor Accidents Claims Tribunal Mandya, MBC 1295 of 2019, dated 9/12/2021. Full stop. As against the claim for 60 lakhs, the tribunal awarded a sum of rupees 23,95,000 as compensation, divided under following heads, A to A. Full stop. Next, arguing the matter, learned counsel for the appellants contends that deceased Kumar as a skilled carpenter and interior decorator was earning rupees 25,000 per month. Full stop. However, without appreciating the said fact, the tribunal took the notional income of the deceased Kumar as rupees 14,000 per month. Full stop. Learned counsel also states that to establish the occupational income of the deceased Kumar, the appellants produced Exhibit P9 letter. Exhibit P9 letter. Full stop. Learned counsel thereby seeks to take the notional income of the deceased Kumar, to take the notional income of the deceased Kumar as rupees 20,000 per month and enhance the compensation. Full stop. Next, the submission that is made by Sri Ravi S. Samprati, learned counsel for respondent number 2 insurance company, on the other hand, is that the appellants failed to produce any convincing proof with regard to the occupational income of the deceased Kumar by the date of accident. Full stop. Learned counsel also states that the genuineness of Exhibit P9 was not established by the appellants before the tribunal by examining the author of the said document. Full stop. Learned counsel contends that the amount awarded as compensation by the tribunal is highly justifiable and thus the appeal is not maintainable. Full stop. Next. Taking into consideration the age of the deceased Kumar as about 41 years by the date of accident, the notional income as rupees 14,000 per month, adding 25% of the earnings towards future prospects, deducting 1/4 of the earnings towards personal and living expenses, applying the appropriate multiplier 14, the tribunal came to a conclusion that the amount which the appellants are entitled to towards loss of dependency is 22,05,000. Full stop. Also, the tribunal awarded rupees 40,000 towards loss of spousal consortium, rupees 40,000 towards loss of parental consortium, and rupees 80,000 towards loss of filial consortium. Full stop. Apart from that, the tribunal also awarded a sum of rupees 15,000 towards loss of estate and rupees 15,000 towards funeral expenses. Full stop. Thus, the amount that is awarded as compensation by the tribunal is highly justifiable. Full stop. The findings of the tribunal are as per the norms established. Full stop. Therefore, this court is of the view that there are no grounds to interfere with the well-reasoned order of the tribunal. Next, resultantly, the appeal stands dismissed without cause.
Serial number 38, K. Shantaraj.
My lord, I am for the respondent, my lord. Recently, I have received the copy of the memo, appeal memo, and forwarded it, my lord. I will file wakalat within a week.
Then counsel Sri D. Vijay Kumar appears through VC and seeks time to file wakalat. Full stop. Time for 2 weeks is granted. List on 14th October.
Much obliged.
Serial number 39, Girimalaya. FS Dabali.
No representation on either side on call. To give fair opportunity, list on 15th October.
Serial number 40. Banu Prakash HV, CR Ravi Shankar.
Same order.
Serial number 41, adjourn 42. NR Rangegowda, B Pradeep for respondent.
42. 34 days delay in filing. No objection, maybe condone 34 days. Trial court's records will be called.
IA-1 of 2023 is filed, seeking the court to condone the delay of 34 days in filing the appeal. Full stop. Heard. Where is the delay? Heard. Sri Rangegowda NR, Land Counsel for the petitioner appellant, as well as Sri Pradeep V, Land Counsel for respondent number 1. Gone through the contents of the affidavit given in support of the petition. Full stop. Having considered the ground urged, the delay as prayed for is condoned. Next, admit, call for the records from the consent tribunal, list the matter under the caption final hearing on 22nd October.
Serial number 43, Soumya R. Pawan Kumar, respondent.
Additional document accepted.
What is IA-1 of 2024? Production of additional documents.
Additional documents, charge sheet.
Let us call for the record, Mr. Counsel. The record received?
No.
No. Heard. Your good name, Mr. Counsel?
Santosh.
Heard Sri Santosh, who represents Miss Soumya R, Land Counsel on record for the appellant. Also heard.
Rashmi MS.
Heard Miss Rashmi MS, Land Counsel, who represents Sri Pawan Kumar, Sri Shivanagoda, Land Counsel for respondent number 3. Admit, call for the records from the consent tribunal. List the matter under the caption final hearing on 28th October.
Serial number 44, NR Rangegowda, B Pradeep.
30 days delay in filing the appeal, my lord. The case of injury.
Any objection?
Interest may be waived.
IA-1 of 2023 is filed, seeking the court to condone the delay of 230 days in preferring the appeal. Next, heard Sri Rangegowda NR, Land Counsel for the petitioner appellant, as well as Sri Pradeep B, Land Counsel for respondent number 1. Gone through the contents of the affidavit given in support of the petition. Full stop. Though the delay is inordinate, having considered the grounds urged, this court is of the view that the delay as prayed for is required to be condoned. Full stop. Hence, the delay is condoned. Full stop. However, the petitioner appellant will not be entitled for any interest over and above the amount that is granted by the tribunal, if any, awarded by this court through the judgment in the appeal.
Trial court's records required.
Admit, call for the records from the consent tribunal, list on 29th October.
Serial number 45, Pawan Chandra Shetty, PN Srinivas.
For appellant, my lordship, kindly matter may be referred to Lok Adalat, my lord.
Your good name, Mama?
Akshaya.
At request of Miss Akshaya, Land Counsel who represents Sri Pawan Chandra Shetty H, Land Counsel on record for the appellants, the matter is referred to Lok Adalat for settlement. Bless.
Serial number 46, Shripad Shastri, B Pradeep.
Yes, madam. Received through WhatsApp, my lord, in records, my lord. I need a week's time, my lord.
No representation on appellant side on call. Sri B Pradeep seeks time to file wakalat for R2. Time for 2 weeks is granted. List on 30th October.
Final hearing matters. Serial number 47, adjourn 48.
Appealing for the second.
K Shantaraj,
Both
B
the
Pradeep.
No representation on appellant side on call. Full stop. As Sri B. Pradeep is on record for respondent number 2, office is directed not to show the name of Sri B. C. Shivanagowda. Full stop. List on 25th October. List on 23rd October.
Serial number 49, G. Ravi Shankar Shastri,
Appellant, my lord.
P. Hegde Mulkhan.
My lord, short question, my lord, only quantum enhancement I have sought for, my lord.
Where is the other side?
Online, my lord.
S.V. Hegde. He's online. Sir, mute ಆಗಿದೆ ನೋಡಿ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ. ಹೆಗಡೆ ಸರ್, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಸರ್, ಎಸ್ ವಿ ಹೆಗಡೆ ಸರ್.
ಅವರು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿದಂಗೆ ಇದೆ.
We'll have it on 9th September.
Lord, may I seek one request, my lord? The MACT had awarded only 50,000 as compensation. The claimant could not withdraw that amount, my lord. He is persisting for that.
If the other side is present, we'll dispose of the appeal.
Therefore, that TCR could be sent back, my lord.
Again, sending back, again getting them, it would be hectic.
The last occasion also, my lord, has observed the same thing, my lord, but party is insisting, my lord, repeatedly.
Coming Tuesday, we'll list.
Please,
On
ma'am.
third Tuesday, next Tuesday.
Please.
Sri Ravi Shankar Shastri Ji is present before this court physically. Full stop. However, there is no representation on respondent side. Hence, list.
Online.
Hence, list on 3rd September, Tuesday.
Please.
Sir, 3rd September. Serial number 50, T. Vijay Kumar, B. C. Shivanagowda.
Representing on behalf of phone number 2.
No representation on appellant side on call. To give fair opportunity, list on 9th September. Come.
Pass over matter, serial number 1, B. P. Radha, B. C. Shivanagowda for respondent.
No representation on appellant side on call. Steps for substituted service in respect of R2 are not taken. To give fair opportunity, list on 9th September. Over. ಗೊತ್ತಾಗುತ್ತಾ ಬೇರೆ ಏನೋ ವರ್ಡ್ಸ್ ಹೇಳಿದಾಗೆಲ್ಲ ಬರ್ಕೊಬೇಕು
ಆ ವರ್ಡ್ಸ್ ಎಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ ಇದು ಬರಿಬೇಕು ಒಂದ್ ಸ್ವಲ್ಪ ಹೋದ್ರು
ಒಂದೇ ತರ ಹೇಳ್ತಾರೆ, stereotype.
ಕೆಲವೊಂದ್ಸರಿ ಆ ವರ್ಡ್ಸ್ ಚೇಂಜ್ ಮಾಡಿ
ಸ್ವಲ್ಪ ಆಗಿರ್ತದೆ.
ಫಸ್ಟ್ ಆಕ್ಯುಪೇಷನ್
ಅದು ಸ್ವಲ್ಪ ಹೊಸಬರಿಗೆ ಹೇಳ್ಕೊಡಿ, ಪೂಜಾ ಸ್ಕೂಲಿಂದ ಬರ್ತಾರಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳ್ಕೊಡಿ.
ನನ್ನ ಕೆಲಸ